Good evening. I would like to call this March 12th, 2026 meeting of the Abington Zoning Board of Appeals to order. The time is now 7:03 p.m. My name is Richard Peterson. I am currently the chair of the board and will be presiding over the meeting this evening. This meeting is being recorded for broadcast by Abington Community Access and Media Incorporated. Is anyone else here recording this meeting? Here's not. The other members of the board are Robert Manning, Richard Negrelli, Andrew Burbine, and Andrew Leverell. Assisting the board is the zoning enforcement officer, Nick Jenks, and tonight, Amy Kressel, the town attorney, representing the town attorneys. As a reminder, all documents must have been submitted to the board prior to tonight's hearing. Documents that are offered at tonight's meeting will be accepted by the board, but the hearing will be continued to give the board and the public adequate time to review new materials. We have a couple small items on the agenda before we get into the meat of things. And then those things are approval of minutes from December 11th, 2025 and February 12th, 2026. I would entertain a motion on one or both of those.
Well, I think maybe we should approve them because they've been going on for the next, going on a couple months here, so. I'd like to approve the minutes from December 11th, 2025.
Second.
All in favor?
Aye.
Okay.
Anybody else?
Motion to approve the minutes of February 12th, 2026.
Second.
All in favor?
Aye.
All right. Okay, the first item on our agenda where people are going to speak is the continued hearing petition of Barry and Karen Clark, Irrevocable Trust for a variance under 175-29 for lot area, lot 1 from 30,000 square feet to 16,214 square feet, and lot 2 from 30,000 square feet to 15,823 square feet. The property is located at 42 Norton Avenue on Assessor's Map 46, Lot 122 in the medium density residential R30 zone. And I'm sure he will let us know who he is and what he's here to talk about.
Good evening, Attorney Questle, the board, and Mr. Jenks. My name is Attorney Sean Riley of 500 Washington Street in Abington. I'm here on the petition at 42 Norton Avenue. As you know, this was continued from last month at your February hearing. Couple of updates since then. I'm returning to represent the interests of Barry and Karen Clark and also Abington Investments LLC, which purchased the property about a week after our initial hearing on February 12th. As we know, the February 12th hearing was continued to tonight, March 12th. The LLC took title to the property on February 18th when Clark's South Carolina seller refused to postpone their February 24th sale date. The LLC provided the Clarks with sufficient funds to be able to purchase that South Carolina home so they would not lose their deposit money. Luckily, the Clarks were able to move out of the Abington home and drive down to South Carolina. They couldn't fly. They had to drive down to South Carolina, and they did before the blizzard hit on February 23rd and 24th. The Clarks completed the purchase of their South Carolina home on February 24th, and Mrs. Clark is now undergoing treatment for her uterine and lung cancer at a cancer hospital close to their new home. I spoke to Mr. Clark again today, and both he and his wife are doing very well. The remainder of the contract terms between Abington Investment LLC and the Clarks will be finalized after the decision on this zoning application is filed. Two other matters came up since the February 12th hearing date. Some neighbors submitted a letter and petition to express their concerns and objections to the pending petition, and I will do my best to address those concerns as we move forward this evening. They cited traffic, snow pile, fire department access, and an objection to non-conforming lot sizes. I brought a large copy of the Clark's plan so that we can review how these issues can and will be addressed if our zoning relief is approved. I need to note that I submitted a letter from Mr. Clark to the zoning board in which he wanted to defend his name and his character, as I had represented to you at the last meeting on his behalf that no neighbor had voiced any objection to the Barrys prior to our February hearing, which was true, but they have every right in the world to file what they did. We can read his letter into the record later if need be. The third thing I wanted to update the board was, after the last hearing, the zoning board had asked the planning board to review all the materials that we had submitted with our initial zoning application, including the proposed plan of the lots and the proposed extension of the street pavement beyond Mr. Gates's driveway, which is across the street, number 37 Norton Avenue. At their March 2nd hearing, the planning board voted to direct the town planner to submit a summary of their recommendation regarding our request for lot area variances to create one additional house lot at the end of the street. I'm sure you may have watched that planning board meeting, and if you did, you saw that the planning board noted the small size of all the other lots on Norton Avenue, and that the planning board was concerned about the effect of the new state law, which allows a property owner to build an accessory dwelling unit, or as we know, an ADU, without any zoning permits or any planning board permits, so long as they comply with the statute. The planning board noted that the creation of the two new house lots shown on the plan, together with a short extension of the street pavement, might be a better option because the decision to build an ADU would still add 1 or 2 cars to the street, but an ADU would likely convert this property into a rental property, which we'd prefer not to do. Specifically, Board Member Rick Collins said, part of his motion, the planning board did not explicitly recommend the lot split because it's zoning board's jurisdiction, but the planning board does not see any reason why not to approve the lot split under planning guidelines, particularly given the fact that an ADU could be placed there without any ZBA or planning board permits, as I mentioned. Several new state laws have changed the world of zoning as we once knew it, and a property owner or an absentee investor can now add and construct an accessory dwelling unit in zoning districts where single-family homes are allowed. A real estate investor who simply wanted to expand his or her rental income could construct an ADU on this property without the need for any hearings with neighbors, no zoning approval, no planning board approval. The ADU could utilize the existing driveway or possibly enlarge it, but there'd be no requirement to extend the street pavement beyond where it now stops at the end of Mr. Bates's driveway. Effectively, under the new state law, an investor can convert this property into a two-family rental property without anything required except for a building permit. This is an option that we are not proposing, but the variances are required to allow the new house instead of a new ADU. I'd like to review some of the information that we already presented briefly at the last hearing for the benefit of those who are now in attendance at this hearing, and to also respond to some of the concerns mentioned in the neighbor's letter. One of the biggest concerns mentioned by some of the neighbors was the concern that allowing the new lots to be what they described as undersized lots would set a bad precedent for creating undersized lots on Norton Avenue or even elsewhere in the R30 zoning district. Such a concern completely overlooks and ignores the number and the small size of almost all of the single-family lots in this portion of the R30 zoning district. This lot at 42 Norton Avenue is unique in that it's situated at the end of a dead-end street, surrounded on 2 sides by an active cemetery. The topography of the lot drops off between what would be Lot 1 and Lot 2, and the existing structure is located to the far left of the parcel, whereas the new lot would be at the lower elevation. A creation of a 16,214 square foot Lot 1 with the existing house and a 15,823 square foot Lot 2 with the new house would not create a new precedent for non-conforming lots on this street for the house lots on Norton Avenue. In fact, as we previously noted, not one of the existing house lots on Norton Avenue is a conforming lot. None of the neighbors' lots comply with lot area, none comply with lot frontage, and none comply with lot width requirements. Many also violate setback regulations. However, our proposed Lot 1 and Lot 2 will conform to frontage requirements, will conform to lot width requirements, and will conform to all setback requirements on both lots. The size of our proposed 2 lots will also be larger than all but one of the Norton Avenue house lots. I'd like to show the board and the neighbors how our new lots will not nullify or substantially derogate from the intent of our zoning bylaws, as it's sometimes easier to see it rather than just hear it. If you don't mind, I'm just going to hand out copies of things you've pretty much already had, which includes the zoning map. I'm going to walk you through these pages.
Thanks, Sean.
Thank you.
I do have extras if there's any neighbors. Okay, if you look on page 1 is a copy of the Abington zoning map. And I'm sorry, Nick, I didn't know that you were going to use the screen. I would have given you a PDF or something, but
I prefer this anyways.
what's that?
I prefer this way anyways.
Yeah, sometimes I do too. Lot 1 is a picture of the Abington zoning map, and you can see I circled the area, the corner of the R30 district where this lot is located. If you turn the page to Lot 2, I've blown up that area for you, so it shows that corner of the R30 district that we are discussing, where 42 Norton Avenue is located. Page 3, I blew it up and I show you the assessor's map. So now you can see where the different lots are in that immediate area. And of course, I marked the lot at 42 Norton Avenue to give you a little idea where you are. You note it's in the R30 zoning district. Turning to the next page, I showed, or I added an overlay which shows where the cemetery is located, which shows that now this area that we're dealing with on Norton Avenue is effectively an island of the R30 in the upper corner of the R30 district, surrounded by, well, our lot is surrounded on two sides by an existing cemetery. The next page, I show you the different house numbers on the street and where people live on that street. The Bateses, Miraglias, I hope I'm saying that name right. Thank you. Thank you. And Twists are on the opposite side of the street. Mr. Gaffney lives next door, number 28. And then the final page, I added one more bit of information, and that is the actual square footage of each of those lots in the neighborhood. Mr. Bates's lot, it's a little odd-shaped lot there, 18,295. Miraglia's, 13,939. Twists, 13,068. Gaffney, 10,019. Our proposed lots are 15,823 and 16,214. So as I mentioned, our two lots are larger than all but Mr. Bates's lots. None of the lots on Norton Avenue conform to frontage, lot width, and there's actually a couple of side yard setbacks, but that's fine. We are trying to do everything we can to conform. The new house, the two new lots, will conform in every regard except the lot area. But I hope this demonstrates to you that what we're proposing is not out of whack with the rest of the neighborhood. It is, in fact, larger than most of the neighborhood. To take that one step further, I wanted to show you more of the R30 zone in this area. Open door, Mr. Manning. Hey, Mr. Manning.
Thanks, Sean.
Thank you.
This is a, sorry, let me use the microphone. This is an overlay of the R30 zoning district on this assessor's plan where our property is located. So all of the yellow is the R30 zoning district. I went through each and every single-family house lot in this area to find what lots actually were conforming, meaning 30,000 square feet or more, 110 feet of frontage or more. And the ones with the red dots are the only ones in this district that conform. Three of them are over near the Frollo School, about 1,800 feet away. They're down on Washington Street. The other two, one is down further on Washington Street, Don Whitman's house, if you know Mr. Whitman, and the other one is on the corner where on Adam Street where the bend is, that house that's set back right along the river. In the immediate vicinity of our locust lot, there is not a single conforming lot in the R30 district. So again, what we're proposing does not derogate or substantially nullify from what the zoning bylaw is doing, and it certainly will not change property values or be out of character in the neighborhood. And again, if I could direct your attention to the plan, I don't know if the neighbors have seen the plan, but you haven't, okay. You don't mind if I turn it, because I know you guys have copies of it? Dave, this microphone's blinking, does that mean anything to you? Oh, now it's on, never mind. It happens. I'm going back, but I just wanted, I'm sorry, are these the neighbors right here, the two neighbors? Yeah. Thank you. This is Norton Avenue. This is the Clark property. This is Mr. Gates's. This is Miraglia's. This is Twiss's. You have the Miraglia's. Twiss's? This is the Twiss's, okay. So I wanted to note again, 18,295 up here, 13,939 square feet for Miraglia's, 13,068 for Twiss's, 10,000 and change for Mr. Gaffney, and then these two lots would be 15,823, 16,214. One of the other things, though, this plan shows you, one of the concerns that was mentioned in the neighbor's letter was twofold, was a concern about snow plowing and fire department ambulance access. When there's heavy snow, the town, it's a dead-end street, so the town plows to the end of the street, but the pavement ends right at Mr. Bates's driveway, as you're well aware. So when we have large storms like we just did, they can't push the snow far enough, so it ends up blocking Mr. Bates's driveway, and that's been a nuisance at some of the large storms. Also, the fire department or a trash truck or UPS, they had troubles turning around. Our proposal would actually extend the pavement beyond Mr. Bates's driveway so that we would have a new driveway on the new lot. So now it takes care, it just completely solves the issue of snow blocking Mr. Bates's, and it also creates now a point where a ambulance, snowplow, whatnot, can make a three-point turn, which doesn't exist now. So the concerns of the neighbors are legitimate, but I think some of them are actually addressed by our plan. And I apologize to the cable community at home, I'm just picking up my papers. I can get to the correct page. Okay. We also submitted, and I'd like to read out loud, a letter from the DPW director, Mr. John Stone, dated March 10th. I was asked by the applicant of the pending variance petition to provide comments on a submitted PMP plan dated February 14th, 22, showing the proposed new lot at the end of Norton Avenue. Norton Avenue is a short dead-end street, and the proposed new house with its associated extension of the roadway pavement would be a benefit to our snow removal efforts, as it would allow us to push and deposit snowbanks well beyond the driveway at 37 Norton Avenue. Under current conditions, the snow piles at the end of the existing pavement can block the last driveway on the right, which requires our crews to return with heavy equipment after large snowfalls to help provide safe passage. The short extension of the paved roadway would also allow our vehicles and other large vehicles an easier way to turn around. This would include snowplows, emergency vehicles, delivery trucks, and trash trucks. In short, the DPW does not object to the creation of the proposed new house lot and recognizes the benefit of the extended street at the applicant's expense, and would make our jobs safer and easier for years to come. Very truly yours, John Stone, DPW Director, and I believe you already have a copy of that, so I won't, right?
I have a copy and I emailed out a copy.
Okay, so I won't bother interrupting you. And just for the record, to further show that, this is just a small copy of that plan, which shows the location of the Bates driveway, and it shows the location of the intended extension of the street pavement. So that issue, we believe, is actually rectified by this proposal. Oops, sorry. If our zoning application is approved, we would be required to install the new pavement in order to create the new driveway, which would improve snow removal and the ability for fire trucks, ambulances, and trash trucks to turn around, which they cannot do under current conditions. Also, it would provide a safe, freshly paved area for kids to play at the end of the street at the dead end, where they could play street hockey or basketball or ride bikes. The addition of one or two new cars is somewhat of a red herring. That was one of the concerns mentioned also. The planning board noted, and I'm sure the ZBA is aware, that an ADU can be constructed, so additional cars could simply just park in the existing driveway, or maybe they want to widen the driveway. But if they build an ADU there, not my owner, but a future owner, no improvement would be done or required to alleviate the Bates driveway or the ability of emergency vehicles to turn around. So the ADU would just be frankly plopped where it is and nothing else would change. I already read that page. I also wanted to further explain that the ADU can be 900 square feet, as you know by state law, by our bylaw. Just so people can visualize that, 900 square feet is pretty much the exact same size as the Maraglia's house, the footprint of the Maraglia's house. Their house, according to the assessor's records, is 881 square feet. So an ADU would be essentially the same footprint as that house. The Twist's house is 720 square feet for the main house, but if you added their breezeway, it's about 1,008. So you can see it's about the same size, and that can be done without any zoning or planning. We think that's a bad move. The planning board, I think, noted their concern, and I hope that the zoning board would also understand that the variances here would be better for the town, might be safer for the neighborhood, and would actually kind of finish this neighborhood with lots that are all pretty much consistent with the current lot sizes. The proposed lot sizes, as I mentioned, if you want to use decimals, we're .36 and .37. Existing houses are .23, .30, .32, and .42. Our house will exceed frontage. Our house will conform to setbacks. None of the others do. Our property is unique in that it is at the end of a dead-end street. It has 245 feet of frontage. There's a change in topography. If you look at the property, the house is on one level, and then it drops down about 5 feet to a second level, and it is bordered on two sides by an active cemetery. There are literally gravestones 15 feet off the back lot line. The granting of these lot area variances can be granted without substantial detriment to the public good and will not nullify or derogate from the intent or the purposes of the zoning bylaw, since lots 1 and 2 will be of similar or greater size and will exceed all of the other dimensional requirements I mentioned. The proposed new lot 2 is already fenced off and with the existing chain link fence. We would note that the footprint of the proposed new house would be no larger than the existing house on 42 Norton Drive. We would respectfully request that the board strongly consider the grant of the variances for the reasons I've done it. The concerns mentioned by the neighbors are legit questions to be brought, and again, I don't know if the plan helps them, maybe it addresses some of their issues a little bit more clearly, but the snow removal is gone, the lot size is comparable, actually larger. It would be a safer issue, and really, we think it's better for the town, better for the neighborhood, if a house is built on that lot, because then it's more likely that it's going to be purchased by a family with 1 or 2 young kids who can enjoy that dead end just as the other neighbors do. Whereas if the variances are denied, then most likely when Abington Investment sells this property, you can bet your bottom dollar there's going to be investors out there that are going to look at this property as a single-family house with immediate potential for an ADU. I can make this into a 2-family rental property without any permits. We don't want to do that. When the Clarks approached Mr. LaPointe and he showed him this plan, and remember, this plan was done 3 years ago. This is not something they were trying to take advantage of the system. They've been trying to work on this for 3 years. But since then, the ADU law came in and kind of changes the game. And the board, I'm sure, hopefully will consider that much like the planning board did, and we hope you'll look favorably on our request for these lot variances. For the final thing, I just wanted to submit for the record a copy of the existing footprints of the other houses. I won't bother you if I can just give one copy to Nick, but just to show that in relation to what an ADU would require, you have houses almost the exact same size that are there now, but you wouldn't get the benefit of the extended pavement or as a separate taxable lot owned by a separate family. I'll step down, answer any questions. I'd like to reserve comment on anything else that does come up, but I hope I kind of got ahead of the game and answered some questions up front. But Mr. and Mr. LaPointe, Glenn Jr. and Glenn Sr. are here to answer. Mr. Clark, I spoke to him by phone yesterday. I asked him if he wanted to fly home. We were going to pay for him to fly home because he wanted to be here to tell you that how sincere he was, but he has medical appointments and was not able to get here. So I want to thank you for your time. I hope I answered a lot of questions, but we're here to answer more if there are.
Anyone on the board have questions?
I have a question, yeah. So, thank you for your presentation, Attorney Riley. So, when you initially presented this petition, the basis for your hardship was essentially the circumstances that the current owners were facing at the time, which I expressed I was uncomfortable with because that's not our purview to essentially judge, what someone's circumstances in life are. That said, now what's the existing hardship? You've taken that off the table because you have new owners.
Right. The hardship has to be more related with the property itself and how, the property itself, where it's situated in the neighborhood itself.
Exactly.
And that's where we mentioned that it is, the board was concerned about setting a precedent. And we're trying to explain or emphasize the fact that there is no other lot in town like this. This is a dead-end street with lots that are all half the size of this lots, that is surrounded by a cemetery. Show me where that exists anywhere else. I know one of the comments in the letter was, if we allow this to happen, then other lots on the street could also split in two. And that just shows a misunderstanding of what's happening here. Because we have sufficient frontage, so we're able to split the lot to conform in some way. All the other lots, two of the lots in particular, are 80 feet wide. You can't possibly split those and make other lots. So our lot is unique on this street, and basically should be treated similar to what the other lots are. It has topography issues, as I mentioned. I don't know if you've been out there, but if you walk from the house down to the side yard, there's a pretty noticeable drop. It was buried in snow for quite a while, but there's a pretty noticeable drop. And we can't buy any more land because it's surrounded by a cemetery.
But I think our town council is going to tell us there's no precedent in the law that allows us to take a conforming lot and break it into two non-conforming lots. In our bylaw, specifically, section 17511 says we're not supposed to do that. So what's the legal precedent that I have to do this as a board?
That's why we're here at the zoning board. You're right, there are zoning laws and there are zoning boards, and the boards have a right to grant variances. And if you think there's enough here to justify the variances, now, the Clarks are still actually in the game. You mentioned that that's off the table. It's really not on the, it's still on the table. They still have a contractual relationship with Abington Investments based on what the result of this hearing is. I mentioned to you, their hope was to be able to sell two lots and to use that to spend the money towards their medical issues. That's still true. It's 100% still true. But I will point back to the lot topography, the lot location, the surroundings, circumstances, all make this, in our mind, a unique lot, creates the hardship where they can't make more land, and yet they're also, it's weird in that they're almost an oversized lot on an undersized street.
My question is, you have two owners here, right? The Clarks, correct? In the paperwork here. Who owns the property right now?
The Abington Investments took title to the property.
So where do we stand with this? I mean, they don't own the property anymore. They put the petition in.
That's okay.
It's okay?
Yep.
All right,
Yep.
just wanted to
Because
be
you
sure.
can have a purchase and sale, you can have a potential purchaser can file an application.
Okay,
They stand
just wanted to
in
make sure
shoes.
that's.
Yeah.
Any other questions for him?
I mean, my only other concern too is, I mean, with respect to the argument that this could be a legal ADU, I mean, the legislature in its wisdom has said basically you can put an ADU anywhere.
Yeah.
And so, I mean, we can't just look the other way on our zoning bylaws because any applicant can come in and say, well, I can put an ADU there. I mean, that's the
You
law.
can't take that threat.
Yeah,
I mean,
we can't be bullied with an ADU for every
Right.
application.
No.
If you want to do it, do it. you know?
And I'm not,
I mean, I don't
You know I'm
intend
not
to say
bullying
that
you.
you're bullying
Yeah,
us,
right.
but just in the sense that that's not a precedent we want to set either.
no, but it is something now the boards have to consider in every city and town across the state now, because it has dramatically affected single-family zoning. Absolutely. So I guess one of the questions is, what's better for the town, what's better for the neighborhood? A 900 square foot ADU that's essentially a rental property on the same lot with one driveway, or a 1,200 square foot house that's on its own individual lot that addresses the emergency turnaround issues, gets more tax revenue for the town, and it's a home for a family, not for a tenant.
Fair enough, but one, there's a legal basis for them to do, and the other one, there's not, for us to carve up a conforming lot into two non-conforming lots. And I can tell you, Attorney Quest will probably tell you that, you know, it's an indefensible position that she be placed in, and you have abutters here who are essentially saying they're gonna challenge us if we grant it. So, you know, where does that leave you as well?
Could be difficult for a challenge because they'd have people who own undersized lots appealing an undersized lot. And frankly, I don't know that, I'm going to do my best to represent the interests of the Clarks and know the points. I understand your role in this process. This is why we have a public hearing. This is why we listen to neighbors. This is why we put our application forward. The board has the right to grant variances, that if they see
They
enough.
qualify, right?
Sorry?
They qualify.
Yeah, it's your decision on if it carries enough, if there's reasons, and I don't want to say, you can take a vote to violate the law, but that's what a variance is. But you can make your best judgment. I think you have the right to grant a variance here. Yes, I don't think it's impossible for you to grant a variance here. I hope you do grant a variance here. I think it's a better solution to all the issues at the end of the street.
Any further questions for you?
I don't have anything else.
Not at this moment, but I will.
Thank you very much. We may have more questions as others come up and speak.
Great, thanks.
Thank you very much. Would anyone else like to come up and speak? If you do, just come up and give us your name and address and tell us what you have to say.
Oh, you're going to stand with me?
Board, good evening.
It's full support.
Good evening. My name's Chantel Twist. This is my husband, Adam Twist. We live at 21 Norton Ave in Abington. We bought about 12 years ago. We live there with our 3 children. I'm a nurse at Boston Medical, and my husband is an electrician. And I'm not good at public speaking.
It's okay.
I tend to ramble, so I actually had a little something prepared. But honestly, I feel like the questions that were raised by the board address exactly what our concerns were in terms of turning a conforming lot into a non-conforming lot, and the whole mention of like the ADU in itself and kind of like bullying us into this tight spot of picking one over the other. But I'll read what I have anyways. It's just a few short minutes. And thank you, of course, for letting us speak. So what I have here was that we would like to respectfully share some of our concerns regarding the divide at 42 Norton Ave, the conforming lot into 2 non-conforming lots, as it already supports a single-family home and is currently usable under the existing zoning. It's actually a very nice house. Our understanding is that the Massachusetts zoning law allows variances only for true land hardships, such as issues as shape, soil, topography of the land, which the zoning board, of course, knows. And this property truly faces no such hardships. The applicant notes that the property borders a cemetery and it's larger than the typical surrounding lots, but that does not prevent it from being currently used. And I will say, when you look up the definition of cemetery in a neighborhood, it's just that, a neighborhood characteristic. It certainly doesn't cause any hardship. And in terms of that lot being larger than the surrounding lots, our houses were built in 1950, before the zoning laws even existed. I think from what I researched was that the zoning laws came into play in 1954, like March 1st, 1954. 42 Norton Ave was built in 1968, so of course the lot size is going to be larger. So in terms of, the argument that all the other houses are undersized, I feel is not valid. To continue on, we think it's also important to note that the property was recently purchased with the knowledge of the current zoning that was already in place. And because of that, it appears that this request is actually not due to a hardship at all, but rather a desire to create an additional development. For these reasons, we feel as though this is not a reasonable request. Again, taking conforming lot and dividing into two non-conforming lots completely undermines the intent of any zoning board. And granting relief in this situation weakens the purpose of the whole thing, really, the zoning bylaws, and could, of course, encourage other similar properties to do the same. For those reasons, we do ask the board to carefully consider tonight whether there is true legal hardship here that's met in order to protect the intent of the zoning board and bylaws,
Thank you.
if that makes sense.
Yes,
Very
thank you.
good.
Does anyone have any questions for her?
No.
Did you have anything you wanted to say?
Oh, that was pretty good.
Okay.
Very good.
Well done, sir. Thank you very much. Good support, good
I think we
support.
have some neighbors who are also more concerned about the safety. I think he had addressed the snow plowing was just like kind of a minor thing, but I don't know if anyone's been down 21 Norton Ave, but the entrance is literally at the train crossing when there's been numerous unfortunate accidents, and that continues to go on just the other day, actually. So I'll leave it to them.
Thank you.
Thank you.
Can I just say something
Oh,
really
yeah, just let us know
Right
your
up
name
and,
and address.
Jennifer Maraglia. And this is
What's
just
your
really
address,
quick.
please?
Jen, 29 Norton Ave.
Thank you.
Thank
For the
you.
record.
Just really quick, when he was saying about this design here and how they were gonna extend the street, that sounds fine, and I can actually picture it in my head. But it's not a cul-de-sac. It's still a thin, tiny street. Whether you have kids playing on the end, the emergency access is still going to be on that thin street, whether you make it longer, and it does abut the entrance to the cemetery. So you're not gonna have fire trucks flying down that side. And then if you add 2 more families, full-size families, you could be adding from 4 to 8 more cars regarding like kids, company. And just, we all have 2 cars each, you know, and then you're just adding more cars. And like we said, if I'm coming down from St. Bridget's and I'm stopped there and I'm waiting for traffic to come this way, I'm on the train tracks to take a left to get down my street, on them. So if you're causing more traffic in that little area that's already seen its fair share of problems, it's not good. And that's it. Thank
Thank
you.
you.
Thank you. Do we have any questions for her? No.
Nope.
Thank you.
Anybody else?
Anyone else want to come up and speak? So let us know your name and address, please.
My name's Dominic Riley. It's my wife Jennifer. I'm really here as pointed what you said, the law. The law is the law. That's it. Should be no other, this meeting's here because of why? Why are we here for? About laws. We breaking laws for him? You break the laws for me? The law's the law, sir, as you said, sir. That's all I'm gonna say. Thank you very much.
Thank you.
Thank you.
What's your address, please?
29 Norton Ave, sir.
Thank you very much.
Okay, anyone else from the audience want to come up and speak? I was wondering, Amy, if you have an opinion on this you'd like to share or advice for us?
Sure. So obviously, as town council, I don't have an opinion. You guys have to make the decision.
I know.
Lucky you, I don't have to make the decision. But I just want to go through the.
Are we closing it to the floor, or we,
Well, I thought she was just, you know,
is that okay?
I'm okay. Do you want me to
Okay,
keep
go
talking?
keep going, yeah.
I can be quiet.
No.
So.
I just want to make sure it was okay that
yeah.
the floor was open.
Yeah.
So soil shape, there's 3 elements of a variance. Every variance has to be treated individually. You can't say, I had a variance, you know, you gave a variance here, so now you're going to give one here, because it's completely site-specific. So it's soil shape, topography. And then the hardship has to relate to the soil shape and topography. There doesn't seem to be any hardship at all because it is a developed conforming property.
Can I ask one question?
Yep.
Why do they put finance in there anyway? Why is that part of it?
If you're looking at, so for example, a variance that has stood up in court is when you have a house and they want to put an addition on, and they have to put an addition within the side setback because the other side of the property
Oh,
has
okay.
wetlands.
All right.
And so that's topography, soil shape. That's actually soil and topography. And those wetlands are not anywhere else in that zoning district. It's like a pocket of wetlands. And so the court held that there was a unique shape or unique soil and topography that created this hardship. They couldn't put an addition on their house anywhere. And it really didn't derogate from the bylaw because I think they only went into the setback for about like 2 feet. So that's an example of a variance that has stood up in court. Any other variance when challenged, usually if Attorney Riley is correct, they have to, a plaintiff would have to first withstand a standing argument. Do they have standing? But once they do, variances are very, very rarely upheld in court. So, I think here, the soil shape topography, the topography claims that it's, it goes down, but there's already a house on the property. The other thing is the location. It just seems, and I'm obviously not as familiar as you guys are, but it just seems to me like Lantern Lane and Brookfield Road also are kind of dead ends that end up in large properties at the end. So I'm not really sure saying that Norton Ave butts up to cemetery makes the actual lot at the end unique. And then I think that the biggest hurdle here is what Andrew already brought up, which is you have a conforming lot that you will be making non-conforming, and your zoning in general and your zoning bylaw, you're supposed to be progressing to more conforming, not less conforming. I think that the arguments that were brought up are excellent arguments for a special permit, but this is a variance, which is a much higher level. And then the only other comment that I would make is just that an ADU, if the ADU was detached, meaning a separate building, that would have to go through site plan review. So it's not, which cannot be denied, but it's not without any permits. That was just said a couple times. I just wanted to correct that.
Thank you very much.
Yep.
Anyone have any more questions for me right now?
No.
I do have a question for Mr. Riley, Attorney Riley, which is, I don't think we know or need to know the terms of the arrangement that the property owners made with our local investors. But having said that, if this is denied, will there be a financial hardship placed on the petitioners?
On the petitioners, on the Clarks, they don't get the
Yes.
full benefit of the bargain. This is a weird situation for me.
I'm aware of that.
Yeah.
Because I was asked to represent Mr. and Mrs. Clark have their own attorney.
Yeah.
And it's owned under the name of the Barry and Kathy Clark Irrevocable Family Trust or something like that. It's on the application.
Yep.
They approached the LaPointes and said, we were, well, you know the whole story. We're going to build this for my son. We did this and it didn't happen. Now, health issues came up, things changed, we've got to get out of the state. Okay. And one of my questions to Barry, no offense to anyone here, have you talked to your neighbors? Yes. And everything was okay at the time. That's why we came in with the first hearing. And since then, the neighbors have spoken up, which is fine. I have no problems with that. When we left here that other night, we didn't think that was an issue whatsoever. We thought everyone was kumbaya, everything was great. And for that reason, that's also why LaPointe said, we'll give you the money to go buy your house. And soon thereafter, the letter was filed. And we're like, and the planning board had said, no, we're gonna remove our objection, we're gonna leave it to you guys to make the decision you think. So this has gone on a little roller coaster ride for us, and we've been trying to react. And I understand the requirements of a variance. And I understand that, I don't mind saying, there has been opportunities. There has been occasions where the boards have granted variances, knowing that it might be not to the full letter of the law, but it's still gonna be what we think is the better option to proceed with and let the chips fall. If someone wants to appeal, they can appeal. That became my best hope when everything started, the chips, everything started happening. That's why we're here tonight. We're playing the cards that were dealt. I hope you do approve the variance. I understand if you don't approve the variance, but I am here to lobby for the variance. So respectfully, we hope you do.
Thank you. Is there anyone else who would like to come up and speak?
I'll speak.
Yeah, please do.
Like Mrs. Twist, I don't like public speaking either, but
Let's know your name and
Glenn
address.
LaPointe, 311 Lincoln, Abington. I'm one of the owners of Abington Investments. Always tough following Sean. He usually covers most of the bases, but I did want to at least speak to the neighbors and say, we understand the neighborhood. I understand your position.
Okay, please,
Let's not get controversial.
please,
All I wanted to
sir, please
say here
stop, please.
was we're
Please
going to
stop.
be respectful to you.
Please
That's all
stop.
we were going to say. That's all.
He's speaking. It's his turn.
Please, sir.
That's all I was gonna say, is that we were gonna be respectful as far as if we do proceed with something there, it would be something that we would hope would fit into the neighborhood. All right, it's something that we would wanna, work with you guys. We do a lot of business in town. We make a pretty good name for ourselves because we're usually fair with everybody. So, again, we bought this from Mr. Clark, thinking that there was no opposition. He said he had talked to all you guys, whether he did or not. He said he had talked to most of the men and gone through everything, and so that was what we were told. all right? We didn't think there was really any issues. There was nobody here at the first meeting for it, nor the planning board meeting. So we were thinking that as far as the house goes, it would be something that we could put up there that would look good in the neighborhood. It would be something we would do a good job with. We always try to do a good job with everything that we do. And, you know, as far as the variance goes, we understand you have the right to say no. I mean, we understand that. But we also think you have the right to say yes to it if you wanted to. And there is, you know, for us, we bought it already. I wasn't going to hold him up. I just didn't feel like it was going to be right. When this got continued, it put everybody in a tough spot. We had already had conversation with him. He was kind of depending on us to purchase this. We bought it. So we took that risk.
Yep.
And you know what, we were okay with that, and I would take it again. It was the right thing to do. We had talked to him, and we moved forward with it. So I just wanted to basically say we'd do a good job with the home. We'd try to respect you guys. We'd try to work with you guys. I didn't think that needed to get controversial between me and you. That wasn't where I was going. Thank you. It wasn't where I was going with that, but.
Right.
The details aren't
Yeah, and I haven't.
one in terms of when someone says, this is what I
Glenn.
told so-and-so, it's.
You're talking to the board.
Sorry, yep.
Yeah.
Anyway, I just wanted to kind of introduce myself to the neighbors. You know, always around if somebody has questions, try to do a good job with everything we do.
Thank you,
All right,
Glenn.
Thank you.
Thank you.
Does anybody here have questions for Mr. Lapointe?
No, I do know that they're,
All right, thanks.
they're great.
Going forward, if somebody's up speaking, don't have back and forth talk. They're recording it for public record, and we can't have that. And I'm not going to ask anybody to leave the meeting, but I'm not going to allow that to continue. Yeah, okay. Just a little fair warning. Okay, I would entertain a motion to close the public.
Motion to close the public meeting.
Second.
All in favor? Aye.
Can I speak?
Oh, I didn't, no one said anything over there. Yeah, we can, let's,
Oh, yep, well,
Motion to open.
we did see him, go right ahead.
oh, nope,
Yeah.
just 1 second. Motion
Motion to open to the public meeting again.
Second.
all in favor? Aye. All right, let us know your name and address. please.
William Harry Davis, 115 Plymouth Street. I'm in the neighborhood, but I am not on the street. And the neighborhood is great. They're all close-knit. They all go into each other's house. They don't just wave. So it's a really, really tight community. But on behalf of Glenn, just like Bate Street, look at how, that was so dumpy so long ago, and he went in there and cleaned that whole place up and improved the value of that whole neighborhood. And I believe by putting in a brand-new house down on the end of the street would actually increase the value of their property too. You know, I'm not into realty, so I'm not quite sure. But if you have a contractor that's in town, accessible, not somebody across the country or whoever, if you're going to deal with somebody, and eventually something's going to be put down there. I believe because the lack of housing, and this is throughout the whole country, you know, it is what it is. But if you're going to have a contractor, you might as well help someone in town. And his latest project on Center Ave, if I didn't own my house, I'd be moving into that place. This place is gorgeous. So I appreciate you holding up the meeting for me.
Oh, thank you
Good
very
day.
much. Any questions for him?
No.
Thank you.
Motion to close the meeting to the public.
Second?
May I just say one last
Oh, come on up and tell us your name and address again.
We
Sure.
never got to it, go ahead.
Yeah.
Chantal Twist again, 21 Norton Ave. Just in terms of like speaking to personal character, obviously, I don't know you, you don't know me, but I will say, as Billy said, we were a close-knit neighborhood, and the reason why we weren't at the first meeting was because we were unaware. And what we were told by our neighbor, who we knew very well, was that he had an investor that would only buy his property if he was able to split the lot. That was the story that was told to us by our neighbor. It's certainly not what is presented today, and that's all I have to say.
Okay.
Thank you. Let's try this one more time.
Motion to close the meeting, open meeting.
Open or close?
Close the meeting.
Okay,
Thank you.
the floor.
Second?
On the floor.
The floor, second.
All in favor?
Aye.
Okay. Discussion amongst the board. I think our first duty is to,
Figure out who's voting, yeah.
yeah, we have.
We already know that. I wasn't here.
Yep.
It's the three of us, right?
Yeah, correct.
Okay,
Yeah.
all right.
I guess my perspective on this is, our first duty is to whatever the bylaws say we should or should not do. And I'm very empathetic to the petitioner's health issues. My parents had almost the same ones. But we still have to act in accordance with what we're told we were supposed to do. And, you know, the Points have a great record in
Yes,
in town. And
Yep,
there's no
agree.
issue with that in my mind whatsoever. So this doesn't have anything to do with them in terms of their reputation. But I just feel like we really need to not make something more non-conforming. It just seems like it's our duty to do that.
Right, yeah.
But that's just my
And
opinion.
nothing to do with the people, nothing to do with the
Right.
contractor. It's just something that we most likely, I think, feel as a board.
Yeah.
I agree.
Does anybody want to make a?
I'll make a motion to, deny the variance, the petition of Barry and Karen Clark, the revocable trust for a variance under 175-29 for lot area, lot 1 for 30,000 square feet to 16,214 square feet, and lot 2 from 30,000 square feet to 15,823 square feet. The property is located on 42 Norton Avenue on Assessors Map 46. Lot 122 in the medium-density R30 zone. Make a motion to deny the variance for the basis set forth in section 175-11.
Do you have a second?
And 82.
All in
And
favor?
82.
11 and 82.
Thank you for that.
Anything else we should add or anything? Okay.
There was a second?
Second.
All in favor? Aye. A question for Amy. You mentioned during your discussion that this looked more like a special permit thing. If we deny a variance, can they come back and ask for a special permit?
They could, except I looked, and you can't have a two-family in the R30.
Okay. Okay. So then,
So I was
Thank you,
hoping
Mr.
maybe
Rath.
Thank
they
you.
could still take advantage of
Just a point.
two dwelling units, but have a two-family, but it's an N.
Thank you, neighborhood.
R30.
yes, thank you.
Thank you for your time.
Yep.
Thank you, Mr. Jenks.
Good luck with everything.
Thanks, guys.
Are you?
Can I step up just for 1 second?
Yeah, sir.
Thank you for your patience. Just wanted to smooth things over with the person I talked to here. So the next item on our agenda is the petition of 190 Washington Realty LLC for a special permit under 175-21B8 to operate a sober house as a convalescent home and to appeal the December 29, 2025 cease and desist order issued by the zoning enforcement officer. The property is located at 190 Washington Street on Assessor's Map 9, Lot 48, in the medium-density residential R30 zone. And if I could have someone come up here to speak, let us know your name and address and what you have to say.
Andrew Tyne, attorney for the applicant, who's also the owner. My business address is 18 Maple Avenue, Barrington, Rhode Island, 02806. With me today is Doug Chandor. He's the day-to-day kind of operations guy at the house. And also Dr. Anthony DeSciullo, who's involved with the property. He is, I believe, the stepfather of Doug, correct?
Counsel, I don't mean to cut you off.
Go ahead.
Before you start, I just want to put on the record that in my professional capacity, I work for an agency that regularly coordinates with the Department of Public Health, including at MASH and BSAS facilities. So I'm just this is not going to in any way impact my decision. I've seen, in terms of the residential structure, I've seen, good uses for it. I understand there was a time before the, regulation sort of caught up with the environment where there were some bad actors in there, but I mean, those are widely publicized in the Globe and things like that. I don't have any particular inside knowledge, nor do I have any form of prejudgment about this petition. So I just wanted to add that.
Thank you for that, and I don't see a problem
Okay.
with that. Doug himself is in recovery, and I think Doug conceptualized opening up a sober house. So working with Dr. Anthony DeSciullo, they came with the idea of purchasing this home and making it a sober house. Well, I represent one, just to back up, I represent 190 Washington Realty LLC. That's the owner of the property, which is also the applicant. I don't know if the board's familiar with this property, but it's a large house. It's over 5,500 square feet. It's on a lot that's just over an acre. It has 7 legal bedrooms.
Yeah, that's beautiful.
It's, I've seen the aerial views of it. I actually haven't visited it, but I looked at all the photos and the aerial views, and there's substantial parking also. You could fit at least 10 cars in the parking area that's paved, and it also has a 2-car garage. Where it's situated is it's surrounded mostly by a golf course, some commercial properties. I think there's only really one abutter, except for across the street, only one abutter on the same side of the road, and then there's 1 or 2 abutters across the street, but one of them appears to be a commercial property also. It's really a great spot for a sober home. I don't know if the board's familiar with sober homes, but what sober homes are is it's single-family occupancy. It's a family of choice. So people in recovery come together, live together in a single-family environment for purposes of recovery. This house rules that be imposed by the person running the house. So Doug would have house rules that all of the residents agree to abide by as a condition of their residency. And they're very important to the recovery process. Number one, they're practicing abstinence. You know, there's no drugs or alcohol allowed on the property. There'll be certain requirements like attending weekly house meetings, trying to obtain employment, you know, trying to better themselves. Because the whole intent here is that it's a place to live for a period of time. It could be an extended period of time. It could be a year, it could be 2 years, it could be 3 months. It depends on individual circumstances. But eventually the goal is for them to transition to more independent living. So this is really like a step down in the process. Someone may go to a hospital or a detox or a higher level of care, and they're really not ready for living alone. And one of the major factors may be that they simply can't afford it. But also living alone when you're in recovery isn't the best thing until you're truly stable, because when you're alone, you don't have the peer support which is available in a sober house environment. So a sober house environment has these people who are living with you, not all of them, but some become your friends, and therefore support you in your recovery process and make sure that you don't drink or drug and talk you down, and make sure that you honor the rules that are necessary for the house to function properly to help everyone in their recovery process. That goes to something which is important here, which is the number of people that are necessary for this sober house to work. For this sober house, the number that we've kind of come up with is 16. It works well in terms of what the building code allows for this type of house in terms of occupancy. It also works from a financial standpoint because people in recovery do not have a lot of money. That's just fact. A lot of people have sold their assets for the wrong reasons, lost their jobs, lost connections to family. Typically, they're low-wage earners, hourly employees, and they're struggling. So they need to live with other people so they can pool their resources essentially to be able to collectively pay funds to the sober house operator to be able to, you know, live in a nice environment. And this house, I've seen the photos, it's a very nice house. So as a result, sober houses typically operate in a way that's financially accessible for people in recovery. I know Doug's house, he doesn't charge an entry fee. It's just weekly fees, and I believe it's $250 a week, Doug, is that accurate? $250 a week, very affordable because it's all inclusive. It includes, you know, electricity, heat, cable TV, trash pickup, everything. So they know what their expenses are, and it's an amount that can be paid through a lower wage earning job. Another thing, the sober house like Doug's, they don't do credit checks. People in recovery obviously typically don't have good credit. Background checks, they don't do There's background checks to make sure someone's like not a sex offender and violent crimes and things of that nature. They're required to disclose these things on applications, but, you know, petty theft or something of that nature isn't going to bar them from being able to obtain housing. So with respect to the relief being sought today, my client is looking for relief in one of two ways. This board could allow this use to exist legally at this location, I believe in one or two ways. Granting a reasonable accommodation under federal law. So the FHA, the Fair Housing Act, and the ADA, the Americans with Disabilities Act, both provide and allow people who are providing services to a protected class, and people in recovery from substance abuse are a protected class under those federal laws.
Excuse me.
Yes.
That's a disability?
Disability, so people in recovery from substance abuse are considered disabled under federal law.
That is the first time I ever heard that one.
Yeah, because it's debilitating. It prevents people from being able to take care of themselves, their family,
Yeah.
maintain jobs. It's not physical, well, it is somewhat physical
Well, I
in
thought
nature.
disability was disability. I thought,
Yeah, it's behavioral and mental health issues, essentially, is substance abuse.
well, no, you see it here on the paperwork, and it's the first time I ever heard that.
Yeah.
Coming from a family who alcoholics, I've never heard of disability.
Because you become dysfunctional. How the law looks at it is if you're dysfunctional and can't take care of yourself and perform necessary everyday tasks, then you're disabled.
Okay.
So-
I'll remember that.
Yeah, so people, the people who Doug provides housing to are considered disabled, they're a protected class. Doug, as a provider of housing, has the right to request a reasonable accommodation, ultimately for their benefit, to be able to access this housing. And the reasonable accommodation that is requested is to allow, under the town zoning, the existence of this house for these disabled individuals to provide access to housing. And the test under federal law is it reasonable and necessary? And that's what this board is supposed to consider under federal law,
Right.
which is entirely separate from what the board can do in terms of the special permit which is being requested. It's an entirely different test. Under federal law, this board has to just simply consider, is it reasonable and necessary? And the reasonable aspect of it is, does the use cause an undue financial or administrative burden upon the town? And I say no, undue financial or administrative burden upon the town. So is this somehow going to handicap the town in such an undue and financial way that, compared to another use that would be there? So the town zoning allows a convalescent home there, a nursing home there, a hospital there. Potentially, obviously, there'd have to be site plan review, but from a zoning perspective, these other types of uses are allowed there. So we don't think that these individuals, they're not using the school system, they have private trash pickup, they're not an excessive burden to the town. And then in terms of necessary, is this necessary for these individuals to assist them in their recovery process? And I provided some literature in my papers for the need for this type of housing, because it's well recognized that peer recovery systems such as this, sober houses where people in recovery living together, are essential in terms of maintaining sobriety and progressing in their recovery process. Again, back to what I was saying, living alone really isn't helpful for people in early stages of recovery. And they tend to relapse much quicker than people that are in these types of environments. Also, Abington, from what I can tell, other than saying this is a convalescent home, which I think it does fit within that general definition, the town zoning doesn't have a definition of convalescent home in its zoning, so I can only look towards the internet and what that means. And a convalescent home is for people who are recovering from some sort of illness. And substance abuse, alcoholism, all of these things, they're illnesses. So I think it fits within the definition of a convalescent home.
I think the only issue that presents with that is if you're a convalescent home, you have to be licensed by the Department of Public Health, correct? Under Chapter 111, Section 72F.
There's no definition within the town zoning as to what a convalescent home is, so.
But
gotta work
the
on that.
state law defines it.
Yeah, I don't know, because I think the town can define what it believes a convalescent home is.
I guess that would bring up the issue, if we define it as a convalescent home, then are you required under state law to have certification by the Department of Public Health, which licenses convalescent homes and rest homes?
Yeah, I don't think so, because this isn't a licensed program, so I think a convalescent home that you're speaking to probably has providers on site. There's no medical care, there's no treatment, there's no providers on site in a sober home.
So it's kind of like a rooming house, in other words.
Well, it isn't, because a rooming house rents rooms, and these people really have nothing in common in a rooming house. They're renting rooms, living in their rooms, they're not sharing the entire house, they're not supporting each other. I guess they could, but, you know, this is a different thing where they're sharing an entire house. They're not renting locked rooms, sharing a kitchen, sharing food, sharing a refrigerator. It's much different than a rooming house. And, you know, that's why I put the definition in my papers from the statute, which actually allowed the creation of MASH, where it defines alcohol, is it alcohol and drug-free housing? I think that's what they call it, ADF, in the statute, which it describes the type of housing which is, sober houses are their own thing. They aren't, and that's why there's a definition within, I think it's Mass General Law, Section 18A, defines alcohol and drug-free housing, a residence commonly known as a sober house that provides and advertises, et cetera, et cetera. So state law recognizes a sober house as its own animal, because it's not a rooming house, not a lodging house. And there are some cities and towns that have sober houses specifically defined within their ordinances. Haverhill does. They have a definition for sober houses, and they say where they can exist. It's just a lot of other towns haven't caught up in that regard and added it specifically within their zoning so that it can exist. So all I can do as, you know, an attorney working for an applicant is try to see what's closest to it, what's most similar. So what's most similar to allow this somewhere within the town is this definition, which includes hospital, convalescent home, nursing home, I think maybe rehabilitation facility also, these kind of bucket broad categories where, again, there's no definition within the ordinance. So I think.
And in this paperwork, you said there's another one in Abington? There's more than one?
Yes, Doug has told me that there's one 2.5 miles from the house. I don't know, do you know the address, Doug? I don't. No, yeah, so I guess there is another sober house in town. I obviously, I don't know legally how they're existing or what they've done to exist.
He doesn't have, I didn't find a rehab. Fine.
Counsel, I have guess the elephant in the room in terms of questions.
Go ahead.
Why are we at this procedural juncture? I mean, why are we here on a cease and desist? I mean, we're always wary when, you know, applicants are coming for us for forgiveness for something that they've already done, but then they take the position,
Yeah.
we're going to adhere to all the requirements of the law.
Well, I think Doug and Dr. DeShula, when they opened the sober house, they were unaware that the law had changed. So in, I think, May of 2025, the Supreme Court of Massachusetts interpreted 40A differently than the appeals court did previously. And prior to May of 2025, a sober house could exist within any city and town within Massachusetts without zoning approval. They were per se treated the same as a single-family occupancy per the appeals court. I know that because that was my case. So my advice to all sober houses prior to that time frame in 2025 is that you don't have to get zoning approval from the city and town. They have to treat you like a single family. You can move right in, and
It's not your business.
they were respecting that. I think Doug believed that was the law at the time when they purchased this house. Didn't realize that he's not a lawyer, he's not reading cases, he's not keeping up on these changes. I mean, this board's probably never even heard of this either. So he wasn't aware of it. And in 2025, the Supreme Court said that it doesn't have to per se be treated the same as a single-family occupancy. So the town's definition of a family could preclude a sober house from occupying a certain property. And that's why I'm not here arguing that it's a family. If I was arguing it was a family and this board had to allow it as a matter of law, that would be in contravention of what the law really says. So instead, I'm arguing that we're entitled to a special permit because the closest thing is not a family, because your family definition limits to an occupancy of 5. That's not the closest definition. It's this other one: hospital, convalescent home, rehabilitation center, and nursing home. So we're looking for a special permit under that, which I think this fits within. And then alternatively, if the board doesn't think it fits within the convalescent home because they believe that we need to obtain a license, obviously my client's not obtaining a license because they don't provide medical treatment. There's no license required for sober homes. Licensing requirements for sober homes through MASH, which is funded by BSAS, is voluntary. And it's voluntary because you can't require, under federal law, it would be discriminatory to require people that want to live together just because they're in recovery to have to get a license. Me and my 3 buddies are in recovery, want to move into town to live together. Town can't say you got to get a license just because you're in recovery. That's
Oh, now
discriminatory.
we're talking 15 people.
You still can't do it.
Yeah.
So the state recognized that and made MASH a voluntary program. My client has made the application to MASH. He intends on getting certification from MASH. They're in their process.
They're not certified?
They're not. They're in the process of obtaining certification.
Should you just explain for everyone here what MASH is?
MASH Alliance for Sober Housing. It's not that old. Well, I guess it is at this point, 2010. The law came into effect in around 2010 to allow for MASH's existence, which is funded in part by BSAS, or the Department of Public Health.
So the state pays for it?
State pays for a portion of MASH's funding. The other portion comes from sober houses who pay application fees and inspection fees. And what MASH does is it provides an overlay for sober housing. It does not replace the building department. It does not replace any requirements imposed by the town in terms of housing, but it's an overlay where MASH goes in and inspects homes, makes sure they comply with a checklist, square footage requirements, number of bathrooms per person, these things that make the Department of Public Health want sober houses to be safe. So MASH assists in trying to achieve that goal. So they can't require sober houses to register, but clients, when they come to me, I ask them if they're MASH certified, and I suggest they should do it. And Doug is following that path, and he will become MASH certified. And it just adds an overlay, and it helps keep sober houses safe, clean, better for the occupants, so you don't have to read about them in the news where there's been some bad apples out there. So it doesn't, stop Mr. Jenks from doing his job and inspecting properties, but at least, hopefully, it helps properties be safer for the occupants.
And in terms of the occupants, you indicated that they have to sign a contract to maintain their occupancy there and adhere to certain requirements, correct?
Correct. So I think I provided some of the rules, et cetera, and as part of their occupancy, they agree to pay $250 a week, and they sign on to all the rules. They're going to maintain abstinence. They're going to, go to weekly meetings, pursue employment, all of these things which are beneficial for them, and that's part of their contract to live at the property.
And if someone doesn't adhere to those rules, you still have to follow the normal legal eviction procedures, which can be onerous and lengthy?
I tell clients they have to, because I believe that state law does not allow you to waive tenant rights in any sort of contract. So unfortunately, that's something which MASH is working on. They're trying to get some new laws out there to give an expedited process for removing people from sober houses. The reason being is that if someone's drugging in the house, it's very disruptive. And if you have to go through the eviction process, well, one person is disruptive, it's a problem. But my opinion is that they do have to follow those landlord-tenant laws at this point in time and go through the eviction notice to evict, go to court, go back 3 times, and eventually you'll get them out.
So basically, they have to follow these rules.
Have to follow, because they're tenants.
And if they don't follow the rules, you cannot get rid of them until...
It's no different than if I rented my property and said no dogs, and someone had a dog. I can't throw them to the street. I have to go through the legal eviction process. So it's just another rule. These are just rules, and it's no different. So the process is the same. I will tell you that good sober house operators, which I believe Doug is from my conversations with him. They have a good rapport with their clients, with their residents. They understand when they violated the rules, and usually they can have a discussion, get them to a higher level of care, to detox or somewhere else where they need to go, and usually that happens. You'd be surprised. I don't hear very much about people having to go to court to evict people. It's very rare. When they've got to that point, really, it kind of failed. It's just, that's just bad.
So it's gotta be.
So, I could continue, but I mean, I don't want to just go on forever if the board has questions or.
Well, like you said, though, this is something new to us.
I understand.
Not to all of us,
I
but
understand.
Mr.
Yeah.
Chairman, if I may?
Yes, please.
Again, Amy Questle, Town Council. So the application is signed by the property owner, Anthony Disculo, manager. That's not the property owner. Property owner is 190 Washington Street LLC. The manager is, and pardon me, Aminola Kohalu, and then the other manager is Kianush Yazdanseta.
You must have the wrong,
190?
it's 190 Realty LLC.
Oh, sorry, okay.
Yeah, because I did look at it, and I'm pretty sure Anthony paid for the property, right, Anthony?
Sorry. Sorry, that's a huge mistake.
It's fine.
Like, it's a big difference.
Yeah.
So the applicant is 190 Washington Realty.
Yep.
Yes.
I just put in 190 Washington.
Yeah. 190 Washington Realty LLC.
All right. Do you want me to chime in?
Yes, please.
So,
Do you have any other questions for him first before you chime in?
no,
Okay.
I don't.
I don't either.
So
I mean-
my only question,
I mean,
and
not-
sorry, no, this is more for Amy.
Yeah.
So the distinction, I know we've had past circumstances
Thank you
where
very
somebody wanted to create a lodging house, which we said wasn't allowed for under our bylaws. The distinction here is that the owner is living there and then renting rooms, which could be a special permit.
I don't think that is what they're asking for.
I thought they were looking for 21A7, which is renting of rooms or furnishing of board for more than 3 persons when situated in the place of residence of the owner.
That was my cease and desist, how I defined the property.
Isn't the owner
Okay.
living there?
Oh, I understand. Okay, so they're not seeking relief under that provision.
I don't believe so. I
Okay.
have to look for the
The
context.
notice says 21B8.
yeah, be it.
I don't know if that's where that came from.
I got a question for you. I mean, can you just explain why we're here? I mean, basically what you found?
Yes, someone came to my counter, asked if I've seen the website advertising the property. I hadn't. I looked it up, saw that. I had heard about this new case from March. With my non-legal interpretation of it is, yes, people in recovery are disabled.
Yep.
No, they should not be treated differently than anybody else, but that doesn't entitle them to treatment greater than what anybody else would have. These sober homes, they do seem to live as a family. Abington defines family as one or more persons, including domestic employees, occupying a dwelling unit and living as a single nonprofit housekeeping unit, provided that a group of 5 or more persons who are not within a second degree of kinship should not be deemed to constitute a family. If this was 4 people, it would fit our bylaw, they could be considered a family and be fine. There's another smaller but similar one in town. Same, pretty much came to me the same way. They had 5 people, they said, we'll remove one of the people.
Oh,
To be at 4, they live as a family, they operate as a
oh,
family.
okay,
I have no bearing over it.
okay.
This one, I mean, I don't think they want to work as 4. If they were down to 4, it'd be a single-family home.
Right.
One of the big things for me, which if they were, again, if they get any kind of approval from the board tonight that allows them to operate, we're into the building codes with it. I think congregate housing is a good description of what they have.
What was that, housing?
Congregate,
Okay.
that would be the right definition under the building code. They would need to apply for permit to change that use. Everything would be looked at. Significantly, a sprinkler system would certainly be required under that use. I know they're aware of that requirement.
Is that an allowed use in R30 zone?
So we don't have congregate housing.
We don't have it.
as the building code doesn't always line up with the zoning, zoning bylaw. I think a convalescent home could be considered congregate housing too. Those two wouldn't contradict each other.
Okay.
A rooming house is congregate housing. That's kind of the most common use of it. And that's,
Okay, they're just wondering exactly what you saw.
yeah, I mean, I will say when I was in the home, I didn't go through all the rooms, but it kept nice, it's clean, it's,
Yeah.
they seem to respect the property at the very least.
Mr. Chairman? Nick, one of my primary concerns is public safety and safety of the tenants. Given the fires that had happened down in the southern part of Fall River, having 16 people in units are a lot. And fire safety, I don't know, because we don't have anything about this. Fire safety to me is one of the most important for the tenants to be protected in case, God forbid, someone lit a fire in one of the bedrooms. Are there smoke alarms? Are there different rules for sprinkler systems that would not be in a general housing or residential requirement? But in this requirement, they're individuals, not the same. So do we need to worry about, if we go, even if we intend to think about this, there has to be some site, I think you cited in your thing about site review of the property. The safety of the tenants is my primary concern here now. Is I don't know if in a 16-room home, should we not be considered look at having the fire department or coming up with a rule that you have to have a sprinkler system in every bedroom or whatever, because I don't really want to go forward not thinking that these people are not covered and have a disaster happen by mistake.
Yeah, so the zoning decision is independent of the building code.
Right.
To be honest with you, if there was any kind of approval tonight, I would be enforcing that it is congregate housing. And I don't know
Follow the
if there
rules
was
of
something to
congregate
it.
housing? Okay.
It would require an application for that change of use.
Okay.
Full life safety plans,
All right.
everything, almost as if, I'd get plans as if they were, I wouldn't have framing, but as if they were building a new congregate housing
That's
facility.
fine, but that's,
That'd be reviewed by myself and always include the fire department.
okay.
That's something that requires a sprinkler, which the fire department also has their code for that, and
Yeah.
we work well together on it, but they're very,
Well, I
very
was just
active
thinking
in it.
16 people in a house, a single-family home, there are some big families, I get that. But this isn't the term, quote, it's a family, yes, don't get me wrong,
May I respond?
totally appreciate what you're trying to accomplish here.
Mr. Manning, can I respond on that
Yes, sir.
quickly? I've already instructed my clients, if they're approved today in any way, shape, or form, they have to put in a sprinkler and alarm system.
Okay.
That's not an option.
Yeah, I saw that in the paper.
And it's in the letter, and they have to do it, and they know it, and they're already prepared to do it, but they're not gonna put it in if they can't have the use.
I get, right, but since we've never done
No,
this
no,
before.
it's absolutely something that they would agree to a time frame with the fire department to get it done and do it.
No, okay.
Okay.
For me, it's public, when I
No,
call it public
it's-
safety, it's residential safety.
valid.
Thank you, I'm sorry, I didn't mean to, I wasn't.
It's all right.
Amy, you were gonna
But he won't agree.
weigh in, and then we all interrupted you.
Sorry
Yeah,
about that.
you guys do that.
That's why you love
We're
us.
sharp now.
So, my recommendation is to issue the special permit for the convalescent home, which again, does not have a definition in your zoning bylaw. So Nick would treat that as a congregate living.
Can I
and-
just ask on that, though? That's otherwise defined in the law, and I apologize, it's Chapter 111, Section 71, that has a distinct legal definition. So can we create our own legal definition that doesn't adhere with the general laws?
So the problem is that it's much cleaner if you give them a special permit rather than an accommodation. For the accommodation, it's a federal accommodation, so you always have the federal law and the state law, and you always have this kind of, am I covering both? Some people will argue that the federal law supersedes the state law. The back case, the Fitchburg case, basically said, no, it doesn't anymore. Attorney Tyne mentioned that there was a rehab use or rehabilitation use, and I can't find that.
I may have misspoke with that. I went back and reread it. It says nursing.
Yeah.
It says
It doesn't say rehabilitation.
Infirmary, convalescent hospital.
Well, what's an infirmary?
is there, Andrew, is there anything on the?
I believe infirmary is defined somewhere as well, yeah. Charitable home for the aged, convalescent or nursing home, intermediate care facility. Let's see. Rest home.
So if you issue a special permit, you're issuing a special permit for this use. And it's allowed under state law, and it's allowed under the zoning bylaw. You know, they still have to comply with state fire code, state building code. If you issue them a federal accommodation, I personally think that the accommodation should come from the building commissioner, not the zoning board of appeals. Under 40A section 14, you guys do sometimes step into the shoes of the building commissioner, so possibly you could give an accommodation. Normally what would happen is the sober home would come into town and get the permissions that they're supposed to get. So they would come to Nick first, and then Nick would decide if there's an accommodation or not. That didn't happen here. Cease and desist, the cease and desist was appealed, and that's how they're here. And now they're asking for a special permit.
So if we denied the special permit, they could conceivably go to Nick and still get the reasonable accommodation through the federal law?
They could on your recommendation.
If
And if
we,
it's a, I'm sorry, if it's a special permit, we can condition that, right?
You can.
Condition,
And
which is better for
comes,
us.
exactly, and it only applies to this use.
Yeah.
So that means that, you know, they can't change that use and turn it into a frat house or something like that, you know, because they have that special permit in hand. I mean, the accommodation is the same, it's not recorded, it's not, you know, it's not out there as much as.
So that was my question as far as the use. It's going to rely on you. Do you think 16 residents that will be in there?
16 residents. 16 total.
16 total residents in what is a single-family home, correct?
It is a single-family home.
Do you think that's an overuse of that property? Is it too many, do you think?
It's gonna be more than 2 people per bedroom.
Is it open now? Is
What's
it
that?
open right now?
I
Are there
believe-
people in there right now?
I believe so, yes.
Even with the cease and desist?
Yeah, my general, I know I've talked about this before, when I issue an order
That's right.
and it's being appealed, as
You're
long as
okay with
there's
it?
an immediate danger, I generally leave things alone and let it get to the board.
So,
I
so
told
basically,
them not to rent any new rooms, and if anybody leaves, to leave it empty. Pretty much, if you weren't there on, I think it was December 31st, I didn't want you in there. But
So-
who was there, I didn't want them coming out and waiting and hopefully coming back.
do we know when it opened? Do we have any clue how long it's been there?
The property sold in the fall.
September of 25 is when the property changed hands, so.
Okay.
Yeah, it hasn't been too long.
I just,
I think it happened pretty quickly after.
You need
the
to come
property.
to the
Yeah,
desk, yeah, he's yelling at
I
you.
apologize.
September 25 is when they
So
purchased
just
the
back to the
property.
16 residents, do you think that's too many?
I have not seen a life and safety plan yet for it.
Because that would be a condition you could put on, wouldn't it be? Not 16 residents, but 12 or 10?
Oh, you could, yes, you could condition it if you wanted to, but he could also, with the congregate living, he can decide.
That's a commercial
also.
building.
That's a-
They'll
so-
be seeking a certificate of occupancy, which will have an occupant load on
Yeah.
it.
So you can.
It'll be up to them to show me that, how many residents can be in there
Would it
safely.
be better if it was in the special permit versus Nick issuing his part?
So I'm not sure that you could, that you could determine how many people can be in there without a life and safety plan, without a recommendation from Nick or the fire department at this time.
We could ask for them.
You could ask for that, you could continue this and ask for that, to be comfortable that there's 16 total residents is okay. But again, Nick also can do that under the
Right.
state building code.
I like the fact that it would be memorialized in the special.
Yeah, yeah, that's a good idea.
Question, Amy? Is anything we do when we're approving the special permit tonight set a standard by which we have to follow going forward
Not unless,
for a MASH housing request? I
no.
don't want to be tied, because we don't have one. I don't want to be stuck here,
Yeah.
having 5 more people come, because he's so successful, that we don't have rules to follow yet. So I just asking the question generically, if we establish a special permit for this location, we are not bound by those set standards going forward for anybody else who applies for another application. I just want to make sure of that.
You're not, except I'm not, we still have to figure out if a special permit is appropriate, because I'm not sure that they actually, Andrew brings up a good point, that if there's no definition of convalescent home, I think we would have to revert to the state definition.
And there is one under 111, section 70E, is used in the section facility shall mean any hospital, institution for the care of unwed mothers, clinic, infirmary maintained in the town, convalescent or nursing home, rest home, or charitable home for the aged, licensed or subject to licensing by the department.
So they need to be licensed.
So it seems like our regulations mirror the statutory language in that regard, so I'm assuming that's what the reference is.
Yeah.
But MASH is not required to have licenses because they're
No.
not delegating.
Yeah, the whole MASH thing is, it's voluntary.
Okay.
So we don't really take that into consideration at all.
All right.
You know, what we take into consideration when we're doing an accommodation, and I have to work with building commissioners on when they are doing accommodations, and you have to look at how big is the building, how many people are in rooms, you know, and again, is there any impact, negative impact to the town? Which there really isn't ever, because they are self-contained,
Okay.
self-contained operations, I'll call them. So, this board could, you could also do an accommodation for a certain amount of people. So you could put it in without a special permit, you could limit the amount of
We
people.
still would need that.
Yep. So that would be a decision. So you would have, your decision would be a written decision of this board, because they did get a cease and desist and they are appealing it. So your decision on the appeal would be to affirm the building commissioner's decision on cease and desist, but issue a accommodation for whatever it's gonna be, 16 residents, and then subject to the building code and fire code.
So what's the preferred course?
I had one accommodation that they limited the amount of cars, actually, because they didn't have enough parking. Have we?
That was another question I was going to
Yeah,
ask.
do
is
we
the
know about
parking
parking?
Situation.
I'm
There is a
not
parking
aware of
plan there, but-
how many parking spaces are. That's
There's an acre of land there, so it's not like.
I'm
they
sorry,
can't
that's-
come up with more
Well, they
space.
buy wetlands too, though. They start,
On the right side of the, I've actually saw the property today, on the right side, they could actually.
They have, okay.
They could actually expand their parking lot, I think, without too much.
On the right side, there's I believe, a stream.
I was gonna say, that's wetlands.
It's not, but it's not within 20 feet of the existing driveway. I don't think,
The stream,
yeah. Is
they
it
would have a very difficult time expanding their parking there.
Yeah,
in my
would the-
opinion.
Not, and even to the left in the front yard?
They would have a very difficult time expanding any of their lot coverage there, in my opinion.
Okay.
What would they need for parking? If there were 16?
16?
I would think 16.
Yeah,
I-
speak to that quickly. Most people in recovery don't have cars. They just
How
don't.
do they get to work?
They have people who, they usually have a van, or they share driving arrangements, or they have to work it out another way, because people in recovery that probably got hit with a DUI, lost their car, lost their license, sold it for wrong purposes, whatever. They currently have, I think, 9 outdoor spots plus 2 garage spaces. And has that been adequate? Have you ever had to park cars on the street or elsewhere? No. I mean, that's a lot of spaces for a sober house.
One quick question, does that include where the dumpster is? Or does the dumpster have its own area?
I don't know.
Yeah, it's its own area.
So 9 plus then, like a tenth that the dumpster's in?
Yeah, the
Okay.
dumpster actually sits in front of one of the garage spaces. So we don't even need to use the garage for.
Okay, so one of the garage spaces is blocked.
Yeah,
Okay.
yeah, we don't. It's nice.
But if we were to grant an accommodation, then we lose some oversight authority because it takes it outside the special permit process, correct?
Which is the way that you think we should go.
Except now I can't figure out how to get in there.
Right.
What about, so, I mean, I know we already raised this, but
I mean, if I may, I'm sorry to interject,
Yeah, no.
but, a convalescent home, again, your ordinance doesn't define it. So there's a state definition, but the state definition anticipates that there's medical care being provided by that program. That's just not what this is. They couldn't get a license for a convalescent home.
No, I appreciate
yeah,
that, but our
so-
regulations basically say, like, if we don't define it, we borrow the language as.
Oh, is that what it says? You borrow the language from the statute?
That's normally what
Yeah.
we do. We have to find a definition somewhere.
Yeah,
Here's
so we
links
can't
to
just
that.
kind of create our own because it's otherwise undefined.
Here.
What about, A7, renting of rooms or furnishing a board for more than 3 persons when situated in the place
That's,
of residence of the
so
owner?
isn't that an N under R30?
Yeah, but couldn't we grant a special permit for that?
That would need a use variance.
Well, you can, I mean, just a suggestion, you could grant a special permit for an unlicensed convalescent home. The reasonable accommodation is you're allowing an unlicensed convalescent home that has to go through a special permit process and abide by building and fire.
That's not a bad idea.
You know, you're blending federal law with your code.
Are we still covered by the bill inspector and
But
what
do
he's
we-
gonna need?
Sorry, but do we still want to have that,
All right,
what you call it, that the fire
but I-
department and Nick would do?
Oh, yeah, he would still,
But as part of our special, as part of this, before we issue a special permit, is that?
oh, the life safety plan?
Is that something we should do before? If it's got to be done anyway,
Yeah.
why wouldn't we do it and
Yeah,
then
you could.
make it part of our deliberations?
procedurally, I
Yeah.
think I need to ask if there's anyone else in the audience who wants to speak to this, and then we'll close it for board discussion.
Okay.
Is that okay? Would anyone else like to come up and speak on this issue? Not seeing anyone?
I mean,
Yeah,
Yeah,
come
if you
up.
want to come up, come up.
if anybody else wants to talk. I can talk.
Yeah, just let us know your name and address and.
Doug Shandor, 190 Washington Street. I'm the day-to-day operator. I'm also not a public speaker, but I do know sober homes and I do know alcoholism and addiction. You know, I struggle with it greatly myself, and I've been in and out of, oh man, a lot of bad places, bed bugs, managers who abused me, you know, and I came from, you know, a good background, but, you know, the depths of where this place takes you. I mean, I would ask anybody in this room to raise their hand or not if they haven't been touched by addiction or alcoholism in some way. You know, the goal of the Graduate House at 190 Washington Street is to create an environment where people feel relief when they walk in the front door, not dread and fear. And, you know, that's what we aim to do. We sort of lead by example. You know, I'm a pretty, you know, hardcore AA guy, 12 steps, you know, so, you know, I'm not trying to pull heartstrings here and stick to the facts, but, you know, we do provide a safe, clean, respectable environment. We don't even have chores in the house. Everybody just does what they're supposed to do. Speaking on like the eviction stuff, obviously that is a legal issue, but for us, we create an environment and we screen in a way, and we deal with clinical programs where they pass on a lot of information to us about the clients, where we create a space where that seems unthinkable, you know. For someone to just say, I'm not going, seems like an unthinkable thing in the you know, the environment we create. You know, I just pray that we can continue what we're doing. It's a good thing. So.
Thank you.
Thank you.
No, and I just want to clarify my prior comments in terms of bad actors. I think it was more in line with what you were saying before MASH came in and, you know, the state started to regulate these in some ways. There were a lot of abuses amongst the ownership preying on the occupants and sort of some of the conditions that you alluded to. So that's, you know, I appreciate what you're doing and that you're, you know, doesn't seem like there's anything like that in the facility. So, you know, I think it's much needed in the state, and so I can appreciate, as I said, your goals.
Thank you. Any further questions for him?
I just have one. It's called the Graduate House?
Yes.
Okay.
Okay. Okay, anyone else want to come up and speak? If not, we entertain a motion to
Motion
close
to
the.
close the,
Do we want to close it if we're going to do
We
that?
can
Close it
still
for public
hear from you.
discussion. We can go.
Closing it to public discussion?
Yeah,
or shouldn't we not?
Should we do?
Can we just, let me ask.
Yeah,
you,
let's-
If you're going to continue
We're
it
going to do
for
this life
further,
safety.
for further
I
information,
think it's a good.
Yeah.
you're going to want to ask questions.
Right.
Okay,
So,
Okay, we're not gonna do it.
yeah,
okay.
we'll
Very
just
good point.
continue it. So what you're, and just to be clear, what you're looking for
Do you think we would get a report from the police or the fire to find out how many times they've been to the residents? Not saying they have,
Yeah.
but just to get a,
Police I've reached out to, they haven't had anything at the property.
okay, very good.
And it's been about 6 months since it's been
Okay, great.
open. So they're, once I became aware, I made them aware.
What about ambulance calls? Anything?
I'm not sure. I haven't heard of anything.
That would be that would be HIPAA.
Okay, yeah,
Stay
great.
away from it.
Thank you very
Yeah.
much, you're right.
That's why I'm here.
But yeah, no, police said they haven't had any issues with the property.
Very good.
Before the board continues, I would like to hopefully hash everything out, that hopefully Amy doesn't have to come next month.
Oh, come on.
We like having Amy.
She said she-
No offense,
I
no
know we
offense,
don't
Nick,
like
but I
having
like
Amy.
having Amy. That's-
And I like to
I feel better
questions
about my
to jump her
decision-making
with when she's still here after the meeting. So we always take advantage of the time we have, but
Yeah,
I like lawyers.
you do?
yeah,
I do.
a couple things
I'm rare.
I have. Site plan review, planning board.
So you can, well, you could waive that as an accommodation. If you go the route of a straight accommodation, they wouldn't need it. If you're gonna go a special permit for an unlicensed convalescent home, you would put in your decision that you are waiving site plan approval due to the fact that it is a established, it's developed, it's established, and the board has considered parking. And,
So I just want to make sure you guys consider that in your
Yeah.
decision you make.
That we are okay with the parking?
We are.
Okay,
9 spaces is a lot.
okay.
Yeah, I haven't heard of any parking issue there.
Okay.
I don't think many people would be bold enough to park in the street there.
No, not at all, no. Perfect place for it, so.
And then, can they condition it with the requirement to come get the necessary permits and everything through the building code?
Oh, definitely.
I know I'm obviously gonna be able to enforce
Yep.
that myself, but I'd like to be able to-
Definitely, it would be-
If something didn't happen, pull the special
Yeah,
permit.
it would be conditioned that compliance with the building code and the fire code.
Okay.
So 527 too, yeah,
Always like to have two
yeah.
hammers if
Yeah.
I need it. I think another great condition, I'd like to hear if you guys are comfortable with it, if it's approved, yearly inspection by the building, fire and health department.
Yeah, there's no objection to that.
I didn't imagine so, but I think it will already be required in the building code, but if that ever came out, I think these are important ones for us to go through, see how they're going every year.
Fire, health, and what was the other?
Building.
Health, building,
Building,
health,
fire,
and
and
fire.
health, you said fire.
Yeah, we'd be happy to coordinate that and everything. Just have one
That's a great
one visit
idea.
together, and I know currently it's Captain Cotter who does those with me for a lot of other properties in town, and you turn up a lot of little stuff that if
Sure.
you're there every year, it gets corrected every year, and it doesn't turn into big stuff. The ones we haven't been in 10 years, you go and you can find some scary situations,
Exactly.
even from well-meaning people.
What I can do is I can draft up a decision and run it by you, and then you can present it to them.
That'd be great.
So we'll do,
Thank
so
you.
then you can make sure you have everything you need.
So we would
As
have,
long as
that'd be
they
great.
continue, if they want to continue.
we would have to ask for a continuance to do that, right?
When was this application filed? When was the appeal filed?
January 27th.
So you have 100 days, so you should be okay. January 27th, it's 100 days.
February 27th, March 27th. April 27th.
May 7th. Okay.
Yeah.
Yeah, the next meeting will be April 9th, I think. Next meeting, I think, is April 9th.
Next meeting,
And then the applicant would have to agree with the idea of
April 9th.
continuance, right?
Yes.
We
Yep.
agreed to a
Yep.
continuance. So they-
And
oh, could you actually,
Yeah, we agreed to a continuance, so you can do whatever you need to do. Yeah.
I have one
Yeah.
quick question. I don't know, you guys might have a great answer on the spot. What would you guys think is a reasonable timeline to have a sprinkler system installed?
So, they got to they got to open up the street, right, which is when can that happen?
I'm not sure what.
Yeah, because it's, it's.
Late spring.
Yeah. I mean, usually I ask for like 6 months. That's usually something that I ask for. Usually set like a time frame. Hey, get the permit application in within 2 months, right? And then a time frame so you see this progress,
It's a reasonable time.
What about the?
I want to make sure we're at the next meeting and asking for 5 years or something
No.
crazy.
The
No,
hardwired smoke detectors?
that's
That'll be
required.
part of the life safety plan.
Yeah.
I believe the house is already hardwired.
What does it have for smoke alarms?
Yes, they are.
Hardwired.
Are they monitored or are they not monitored?
The
They
one-
are not currently monitored. I'll
They,
have to-
they would put in a reporting system with the sprinklers to the fire department.
Excellent.
Yeah.
Again, that's life safety plan. They'll be
Yeah,
approved by myself
excellent.
and the fire
Yeah.
department, based on the
And
conduit.
who prepares that? Who prepares the?
It would have to be a registered design professional. This is
Will that give
going-
us a recommendation on the number of
It will.
people living there too?
Yep.
Okay.
Yep, that will have an occupant load on it. It'll show paths of egress out. They're turning this into, building code wise, into a commercial building. Nothing's done by property or anything like that. We're talking registered design professional for everything going forward.
So what are you gonna do about people who live there now?
Leave them,
Leave them,
it's still open.
is it still open?
Yeah, if we're leaving, I'd continue to leave them alone.
Well, your orders are, they're the same, so no one new can come in, so
Yes,
it's the
exactly.
same as what it's
Very good.
been.
All right, good.
So I understand we're going to ask for a continuance, vote on continuing this or not, and then in the interim, Amy's going to draft a decision letter, and that would include conditions under which we would.
Yep, and you
Grant a
can
special
modify it at your next meeting
Right.
and vote on it.
Safety.
Yeah, safety and, okay, good. This is
Thank you, Amy.
complex, but straightforward, it seemed.
Sure can.
Sort of game, yeah.
April 9th is that next meeting date.
April 9th?
Ninth, yeah, I looked it up,
April
yeah.
9th, okay. Jeez, we'll be there.
I think he's on, so.
Yeah, and do we have the paperwork to sign a continuance thing?
Yes.
We vote on it? Okay. So I guess then we would entertain a motion to continue this hearing till the next month to provide time for Amy to create a decision letter that we could discuss and debate next month.
And they're gonna supply you with a life safety plan.
Apply to the life safety plan.
Life safety plan, okay, yeah.
Can you just give us a little clarity on what that is? Do you mind? Just because that's a
Yeah.
broad term.
Yeah, no problem at all. So you need a registered design professional, most likely an architect's what you're gonna want for it. It's gonna be a full floor plan of the facility. It'll have occupant loads, paths out. It'll kind of have the proposal for the sprinkler system in it, because it's not in there yet. You'll end up with a sprinkler design professional that's in there, so if those move slightly in between the plans, it's all right.
Okay.
But really, it's addressing the number of occupants and how they get out safely.
Okay,
It's the initial thing we'd want.
okay.
Will 30 days be enough time for them to get that?
I think so, depending on who
We'll find out.
they find. Yeah, you definitely gotta jump on it.
Yes.
I think we should include that in the continuance, that we should have at least a week to review that before, I don't know if they're gonna have time to create something that quickly, but
Should we not require that the life safety plan be submitted 7 days in advance of our next meeting, so we have?
I think we're getting into difficult timelines for them.
That's
It
what
sounds
I'm
like the board's mostly concerned with the number of people.
Yeah.
And that's gonna be a number in the corner of the plan that's gonna be very clear.
Okay,
I don't think you guys are gonna need much time reviewing it to
okay,
very good,
see that number.
very good.
all right, thank you.
Myself and Captain Cotter will be looking at it
Okay,
a little more time, but
So I guess I would entertain a motion to continue this hearing until the April 9th meeting, and with a few objectives listed.
second?
No, we need a motion.
Sorry, oh, take a, motion to, continue, till April 9th,
Second?
Second.
7 o'clock. Well,
7:01 or whatever.
7:01.
7:01.
7:01.
All right, all right. All in favor? Aye. All right, and we'll continue it until next month.
The only thing that I would ask is in the event we run into a hiccup with getting an architect or someone lined up that quick, that we could request another extension, just in the event that,
Yeah.
you never know.
Yeah, it's a tough time of year.
As long as we
So
have,
you have to, Did you have is that just a continuance or who has it? I'm pointing all over.
Just a continuance.
Is it just a continuance or is it an extension of time to act?
It's just a continuous that we voted
So
on.
let's,
We
will
can
you
do
give us
both.
30 extra days to act? Of
course.
So,
All right. That helps everyone out.
Just write that in.
Computer down.
You'd like the May meeting, Amy? May 14th.
Do you have a sign?
Oh, yeah, that works fine.
yeah, that's fine.
Sure.
Sign it. Can you read cursive?
I would just like to say thank you.
Better handwriting.
My kids can't.
Andrew, read yourself.
There you go.
I would just like to say thank you to the,
So
you know,
from May 7th
you're trying to do
to
something
June
for the
6th.
community, and I really
That's the
appreciate
new
that.
100 days.
We just gotta try to figure out what the rules of the
Right,
road are here,
exactly.
but thank you.
Everything be safe. No problem.
So I'll file that with the clerk too.
Yes, thank you.
Well,
Okay.
a lot of people have had patience here tonight. So I'd like to move on to the final item on our agenda. And
Oh, hold on. Hold on. You all set?
Yeah, I'm all set with
Oh,
that.
okay, yep.
You staying for the last?
Thank you very much.
All right, I
Would
just
you
make sure
please?
the right
All
one.
right.
Because everyone's leaving, except
I'm leaving.
No, we still
going?
got one more.
We got one
Thank you
more.
very much.
Come back.
No, you don't have to come back.
all right.
All right,
You're not coming back to adjourn?
See you in April. No.
all right,
We'll take a 2-minute.
yeah, take a 2-minute
2
break
seconds.
here, and then we'll come back. All right, this item on our agenda, the zoning board of appeals, the town of Abington zoning board of appeals will hold a public hearing today at 7:03 PM plus at the Abington Town offices 500 Glenwood's Way, Abington, on the petition of, pardon my pronunciation, Shayla Shaw?
Yes, it's me.
Big, well, of JBS Investments LLC for a special permit under 175-21A4 for a multi-unit dwelling. The property is located at 676 Bedford Street on Assessor's Map 46, Lot 8 in the Highway Commercial Zone. Please let us know your name and address and why you're here.
Thank you, Mr. Chair. I am Attorney Walter Sullivan. I represent JVS. My address is 33 Garrison Road, Hingham, Massachusetts, and you already met the owner.
So I'm Sailesh Shah, and I live at 3 Springwood Drive, Hingham, Mass.
We're here requesting a special permit for a change of use at 676 Bedford Street. Right now, it's currently used as an office space in 2 units. The plan is to change the office space to 2 additional units. So the units there now is 1 bedroom, 2 bedrooms. The 2 additional units would each have 2 bedrooms. I'm trying to figure out how to use this, so there you go. You can see you can see a photo of the building. The building was built in 1874, I believe.
It's back there somewhere.
Back there somewhere. You know, and it abuts, the houses behind it are residential, the apartment buildings on the other side. The only office space around it is the new office space that was created on the other side of Shaw Street. It's been used as a law firm since 1983 until the attorney retired and sold the property to my client. So here's a photo, an aerial photo, and these are the side views of it. And I'll let Mr. explain the plan for the inside the building.
So we are not changing any footprint. It's going to be same footprint on the first floor. There is an office about 2,000 square feet. We are converting into like 2 two-bedroom apartments. Reason we do it is like, I'm a realtor and I've been doing this for so many years and I maintain about 60 tenants. So commercial is not a demand right now. And I have few like listings for 6 months and 1 year for commercial property and nobody is interested. Versus for residential, even though without posting, I've been getting like calls for like, do you have apartment, do you have apartment? So it's advisable to have residential versus commercial. It's very small office and use of this office is either attorney office or realtor office. They all work out of the home nowadays, so there is no demand for this. So we would like to request can be converted as a residential, and we can use it.
So this explains how the units are set up. I'll let him explain what exists now.
So the gray area is already exists two-bedroom apartment, and this is the proposed plan of each two-bedroom. And it does have like a 4 egress right now already. So we're gonna be using the same 4 egress, 2 each for the 2 units.
And as you know, the interesting thing is today is, you have over a 20% vacancy rate on office space on the South Shore, more than that in the city of Boston and surrounding area. There clearly is statewide and in this community itself need for more housing. This fits right in with the community. It won't be detrimental to the community because it is surrounded by residential use. And this was a residential house when it was first built. What you'll see is this shows the parking. Under your off-street parking requirement, it only requires 9 spaces. There are 11 spaces that exist on the site now. So there's more than enough parking to meet the off-street parking requirement.
I'm sorry, how many spaces were there? 9?
We need 9 spaces.
There's
You have
11.
11?
There's 11.
Okay, thank you.
You had said the structure was built in 1847. You really can't do much with the building in order to make it into into any type of office space. It's actually pretty cool. Inside, you can still see the original panels and everything that exist when the house was first built. So I think this is the best use for the property, and I think it's actually best for the community as well. There'll be less traffic coming in and out of it than what you would see at an office space, especially given how traffic is flowing up Bedford Street and coming out of Shaw Street, that this is actually better use for the property than what it has been used for. Oh, that's
the last.
But we do meet the requirements for a special permit. It's not detrimental to the community, has no impact on SOAR, et cetera, because the building's already being used as office space.
Attorney Sullivan, is the new development all along Shore Ave?
No, the building doesn't change. The building stays as it is. The office space.
He's gonna develop the office space?
Right.
That was the law firm.
Okay.
To the right of it, on Shaw, is one of the apartments. That's the first floor apartment.
Okay.
And then there's an apartment above
The
that
second.
one.
Okay.
So for purposes of the office space, if you're looking from Bedford Street, on the right-hand side, there's an exit onto Shaw Street.
Yes, there is.
In the front, there is
A main-
entrance exit. In the back of the office, there's an exit and
For
exit.
the parking lot.
And then if you look to the left, the driveway that brings you out onto Bedford, there's actually an exit and entrance out of there as well.
So all 4 of these units will be in the existing frame of that building?
Yes, nothing changes outside.
Yeah, frame stays the same.
Okay, and you're gonna have 4 kitchens, 4 bathrooms?
Yes, so 2 already is there, and we're gonna add
For
2
the
more.
1 and 2 bedroom, they already have their own?
They already have their own
Units.
kitchen and bathroom, yes.
Okay, so you're just gonna add 2 more bathrooms and 2 more?
Yes, 2 more kitchens, yes,
And bedrooms?
and in bedrooms, yes.
Okay.
And this will have to go through site plan review with the planning board, correct?
Yes.
Yes.
So,
What zoning district? I missed the zoning district.
commercial.
Highway commercial.
Highway commercial.
So it requires a special permit
Okay.
for
Yep.
3 or more dwelling.
Yep.
Yes, I spoke to Liz. I came into this after everything was filed. Spoke to Liz, she said, okay, if the zoning board of appeals approves it, then you come over to us for the site plan. review.
Okay, just wanted to make sure. Okay.
Yeah, because it's a change of use.
Yep, yeah, thanks.
Anyone have any more questions for them?
And with that, if it was granted, could they bring that back to a business because of special permit?
Because they need
No,
another.
unless mixed use is allowed. And, well, highway commercial, they could probably turn it back to an office. Yeah, a professional business or financial office is allowed. Yeah, all offices are allowed in the highway commercial.
And this already had apartments in it, which is unusual.
Yes.
But I think it would probably be,
But we don't even have to consider that right now they're a non-conforming, pre-existing non-conforming use because they can get a special permit for a multi-unit building, which is what this is. So you're just giving them a straight special permit. You don't have to worry about changing a non-conforming use to,
okay.
It actually would make it conforming.
Yeah, well,
Sort of.
special permit,
Sort of,
yeah.
Through special
So-
permit. to make it
Yeah.
conform. Thank you.
Okay. If no one else has questions for them, I'll ask anyone in the audience who wants to come up and speak.
No, they're my nephews.
Okay.
Oh, okay.
Eventually, they're gonna live there.
they'll be in favor.
That's just about,
There you go. I like it.
So I do know one thing, that area there, it does have a lot of apartment buildings and stuff like that, and we had the big battle across the street there.
Yes, we did.
And,
They're just finishing the conversion. as we speak.
Right, so I mean, it's not unusual, let's just say that.
No.
And it's not a huge, I mean, what, 2 additional apartments? I mean, it's not really.
Overused, and they don't even do anything in the
Yeah, we're
outside.
not changing the framework of the existing building.
And also the parking's good too, so I mean, there's a lot of good hits right there.
So the parking is conforming, and you're saying that it's not, the 4 units is not gonna be any more detrimental to the neighborhood than the existing, okay.
So-
Again, yeah, the neighborhood's that way.
So should we?
And that's because, I'm sorry, Mr. Chairman.
I'm sorry,
And that's
go ahead.
because there are, I know, somebody said something about an apartment building right near it, abutting it.
Yeah,
Yeah.
Yes, right next door.
And there's all housing behind it. It's all residential behind the building.
So Amy, it's the Eastern Bank, it's a residential, I think it's a 12-unit building, it's a
Yes.
brick building.
Yep.
There's this building, then there's Shar Ave, and right next to it, we just took a commercial property there and converted 3 apartments there.
Okay,
And then after that is the former art studio, which is now a dental office.
Right, exactly.
And then you go down to commercial space.
Perfect. Yeah.
So there is some,
got it.
Multiple dwelling uses already in the existing
Okay.
land on 18.
Just in case Nick asked me to draft this decision too.
I just find it
I like
interesting.
to have some
that-
facts.
I find it interesting there's apartments there and a business, that's interesting. I mean, before they bought it,
Who
so.
was the attorney there before? I passed that sign a million times now. Like, was it
Oh,
Atwater?
the one that-
Susan.
Susan Atwater?
Yeah, she's
Something?
70-something, she reached 70-something.
Yes, yes. She was out of Milton, I believe, so.
Nice lady.
All right.
I think we should
I shouldn't tell
entertain a
you.
motion to close the public part of the hearing so we can.
Are we sure?
That's.
We're sure that the cousins and the nephews.
The nephews didn't volunteer.
I should know better.
Motion to close the open meeting?
Second?
Second.
All in favor? Aye. Board discussion, this seems really straightforward to me.
Me too.
Like, really
I'm
straightforward.
not voting, you guys are.
What's that?
No, no.
I said, me too, but I'm not voting, you guys are voting.
Exactly. But like you said, I mean,
I
we're
don't
through all
see any,
that.
Mr. Chairman, I don't see any issues with this.
Okay.
You're turning it to a residential use and an antique building, I love that kind of stuff.
It's got a crazy roof line, did you see
Yeah.
that?
Yes,
Yeah.
very crazy.
Yeah.
Yeah.
Can't wait to see how they finish it up.
Yeah, exactly.
We gave it away.
So, I guess, what kind of discussion should we have?
I think we really.
You actually just went through,
Yeah, we really
you
nailed it.
just went through the special permit standards.
Yeah,
And then they're gonna go to site plan, and so the planning board will talk to them about, any kind of dumpster location, the parking, their parking is conforming, so there's nothing there, so,
Or you can put snow and something.
yeah, snow, that kind of stuff, that's what the site plan will do. So you guys are just looking at the use, and the use is not gonna be any more detrimental to the neighborhood
exactly.
as the existing, so you should be good.
in that case, then, I would entertain a motion on this petition.
I'll go with you.
Okay, go ahead then.
You sure?
Yep, go right ahead.
All right. I'll pay Andrew if I mess it up in any way, shape, or form. On the petition of Shayla Shah of JVS Investment LLC for a special permit on this 175-21A for a multi-unit dwelling in the property located at 676 Bedford Street on the Mass Assessors Map 46 Lot 8 in the Highway Commercial Zone for approval of a 4-unit, which will be not more detrimental than in the current neighborhood as it exists today.
I second.
All in favor?
Aye.
Good luck with everything.
Thank you for your time.
Thank you so much.
Thank you, Ian, for staying.
Thank you for your patience tonight.
You're lucky it
Oh,
wasn't
yeah,
long.
thank you.
Yes, I know, I'm lucky, I would have heard from you.
I will. Motion to close?
I second.
All in favor?
Aye.